Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Protection of Women Against Sexual Harassment in Workplaces Bill 2010. As the name specifies, the bill provides protection to women at workplaces and also provides complaint redressal mechanism. To discuss the issue, I have with me Ranjana Kumari, President Women Power Connect, and Geeta Luthra, Senior Advocate. Now for the headlines. The bill defines sexual harassment includes verbal or physical conduct that is unwelcome. The bill proposes penalty for women who are caught making false complaints. And the bill excludes the largest section of women workers, the domestic workers. The Protection of Women Against Sexual Harassment in Workplaces Bill 2010 defines the term sexual harassment and seeks to protect women from it in workplaces. The bill also provides a mechanism for redressing complaints and also seeks to punish women making false complaints.
It was only after several members of the Indian women's hockey team complained against their coach that sexual harassment at workplace came to light. It is this kind of violations the policy makers would like to deter. The government proposes the Protection of Women Against Sexual Harassment in Workplaces bill. The bill seeks to grant level playing field to women in workplaces. It seeks to safeguard them as well as provide for a better environment to work.
Broadly, what it sets out is that it recognizes that women, when they go out in the public sphere to work or in any other sphere, even private homes to work, they do face a certain kind of discrimination, a certain kind of harassment which is peculiar to them and specific to them because of their gender. Therefore, recognizing that this is a violation of their rights, it is setting certain measures to prevent it and to punish those who indulge in it.
Seeks to exclude educational institutions. And today in schools, in colleges, universities, you have a lot of sexual harassment of students. So it has forgotten a huge area of sexual harassment, left them out completely.
According to the bill, sexual harassment will include unwelcome sexual behavior. This behavior could be a physical contact and advances, demand for sexual favors, sexually colored remarks, showing pornographic material, and any other unwelcome physical, verbal, or non-verbal conduct. To take action against such behavior, the bill proposes every organization and its branches with 10 or more employees to form an internal complaints committee. The committee will be headed by a woman employed at a senior level in the organization. To give more teeth to the committee, the bill seeks to endow it with powers of a civil court for investigation. Wherever this is not possible, the district officer will have to set up a local complaints committee. The head of the complaint committee should be an eminent woman in the field of social work.
When sexual harassment takes place, under the Vishaka guidelines, the woman can decide who should be transferred. She can say, I want to be transferred, or she can say, my boss should be transferred. This bill says transfer of the woman or the employer, but at the discretion of the employer and the complaints committee. Punishment of the woman becomes possible for a false complaint. And there are many cases, I've dealt with so many genuine cases where the complaints committee has come to a conclusion that the woman has made a false complaint. Genuine cases.
And sexual harassment at the place of work is a great deterrent which inhibits them from working or getting what is due to them. So that issue was examined in the Vishaka judgment. And you see, since there was no legislation to cover the field except the general law, which of course is very difficult. I mean, you see, you go for offences under, you see, the IPC or whatever. Now, that is not something which is very feasible.
The Standing Committee of the Parliament, which studied the proposed bill, said that 13 years after the Supreme Court guidelines were made, virtually all directions remained on paper in majority of workplaces. The Supreme Court for the first time gave detailed directions to protect women at workplace in 1997. The landmark judgment is popularly known as the Vishakha judgment. The judgment had proposed similar guidelines and sought to plug the policy gap which has since existed.
The issue of sexual harassment at workplace came to public glare after the Vishakha judgment by Supreme Court in 1997. In absence of any specific legislation covering this issue, the court had to refer to right to life and equality under the fundamental rights of the Constitution. With camera person Nitin Gupte, Reshma Roy, Rajya Sabha TV.
The bill leaves out educational campuses. Ma'am, the first question to you is, the point made by Colin, he straight away said that in Vishakha it was clear that women will not be transferred. The person who's complaining will not be transferred. But the bill ensures that the complainant or the person who's approaching in favor of the bill or who seeks to be protected is and could be transferred. Now, how do you iron this out?
Well, I think this is the weakness in the bill, and we have been discussing that. There are three reasons why this bill is very important, and Vishakha judgment has already established that. A, there is no enabling environment in the institutions where women are working, from construction site to corporate offices. Women are very worried about complaining because they will be blamed for the complaint. Number two, that when they complain, wherever there has been, many decisions have been there. We are on many sexual harassment at workplace committee on very prime institutions of the country. And we know that ultimately the punishment is directly, indirectly meted out to the women only. She will be told to take some other option, go out of that particular office, go to some other and get transferred. And thirdly, which is very important, is that, women who complain by the peer group, there's a lot of, kind of pressure against her, in terms of her own character assassination. So she herself gets, normally
reluctant.
withdraws.
Yeah.
She's reluctant and withdraws because she is not in that power play of that particular office.
Exactly.
You see, there's in power relation, she is, somebody who is at the receiving end.
Yes.
So I think it is very important to ensure, A, that you should not punish the person who is complaining. If you keep that provision, you are already curtailing any kind of possibility of complaint.
Ma'am, I'll bring in the educational institution, including educational institutions into this bill. How important is it? Because Colin clearly said that is one of the places where most of the...
Yes, I've in fact handled several cases where educational institutions, there's been harassment either for PhD students, teachers being harassed by the principal, etc. So unless, that's I think one of the most biggest focus areas, and you would see that from several cases of Western countries where you see that the highest number of complaints are of academic institutions and campuses where students are complaining against the teachers. So you possibly cannot leave that out. You possibly cannot leave that out. That is one of the focal areas. And even if you leave that out, because of the nature of relationship, there are bound to be lot of hidden cases which will never come to light. But at least they should be included in the first place.
Ma'am, I'll give you some statistics for both of you. There are total 68 central ministries in the departments in the central government. Out of the 68, the parliament asked them, a question was raised that how many have reported sexual harassment cases? 50%, only 33 ministries reported back saying, yes, we have received. Only 50%. Of the states, all the 20 states and union territories, only 2 states reported receiving complaints of sexual harassment. Now, the point I'm trying to understand is, if this is such a big issue, and if Vishakha judgment came as early as it did, why have we not been able to at least put in the basic preventive precautionary measures in place?
Yeah, this speaks volumes actually about the situation of sexual harassment in the country and also possibility of complaining. First of all, it took years and years, and even now there are institutions in public sector and also in the government where you do not have the sexual harassment at workplace committee. The committees are not in place. If committees are in place, there is no proper framework for the committee. What are the rules and regulations for the committee? How the committee is being empowered? Because we know that committees are not being empowered. They are only referral bodies. They go into the investigation, refer it to HR department. And now then HR starts playing its own game in terms of who should be punished. So I think less number of cases are certainly a kind of indication in which we can clearly say that women are not feeling comfortable, they have not been given a possibility of complaining. It doesn't say that there is no sexual harassment at workplace. I mean, there is not an institution in the country where you can go and say that, women are not being harassed when, some or the other kind of complaint is there, but they are very, very inhibited and shy, and also because of social stigma attached to such situation, they're not complaining.
It's time for us to head into a break. When we come back, we will tell you what the Standing Committee of Parliament has said about the bill. The proposed law includes women working in both organized and unorganized sectors. The bill leaves out the largest section of women workers, the domestic helps, out of the purview of the bill. The parliamentary panel has asked the government to include domestic workers in the proposed law.
The complaint of sexual harassment of a domestic help by a Bollywood actor brought to light the environment in which domestic workers have to work. According to a study conducted by United Nations Human Rights Commission in the year 2000, found that there are over 7 crore women who work as domestic helps all over the country, but the government is reluctant to include them in the bill.
It leaves out domestic workers, millions of them in the country, young girls being sexually molested at their workplace, in the homes of people. Many horrific examples of physical abuse and sexual abuse of young girls, tribal girls and so on. It's left them out completely.
The arguments on the other side was, of course, the worry that the workplace is the home, and the home is a space where we are worried about allowing law enforcement agencies to enter that space.
The department-related standing committee which studied the bill has proposed several changes. According to the Standing Committee report, privacy of a household cannot be an excuse to shield acts against women workforce. The committee has also recommended training for members of complaint accepting committees, as not all of them are expected to be legally qualified. The committee also is in favor of granting of suo motu powers to the complaints committee so that even if the aggrieved woman does not want to file complaint, action can be taken. The committee has also recommended that the government explore making the bill gender neutral so that male sexual harassment can also be covered.
Well, I think, it should be gender neutral. It's true that most of the cases of, sexual harassment, which really is the reason for this step to be taken, is of sexual harassment of the females, no doubt about it. But instances are not wanting, even though they may be rare, where there has been sexual harassment even of males and false accusations against them.
The bill was introduced in the Lok Sabha in the winter session of the Parliament in 2010. It was then referred to the Parliamentary Standing Committee, which found ambiguity in the definition of the term employer. It also specifically stated that it should include house owners and landlords within the definition of workplace. Reshma Roy, Rajya Sabha TV.
The parliamentary panel has suggested that the bill be made gender neutral. The first question to you, ma'am, is home is a private space. If you need to include domestic workers, obviously they need to be, that's the largest section that is there in this country. If we need to include that, then are we exposing the homes, the private space of any individual, to interference? That's the question.
See, the private space of every individual is already open under the Domestic Violence Act. It's already open when you have abetment to suicide and suicide. It's already open when you have dowry death cases. So there's no reason why the domestic worker should be excluded. It's the same private space, and you have to enter that private space if you have to respect Article 14 and 15. So there's no answer to that. That's not an issue.
Perhaps, ma'am, is the government scared that the number of cases under this bill, or when it becomes a law, is likely to go to such an extent that it will become unmanageable? Is that an apprehension? That is why they want to keep domestic workers out of the purview?
Well, I think it is unfounded apprehension, because also there is an employer-employee relationship. There is a certain amount of wages given to the women who are working there, and this is applicable to every informal sector worker. You know, there are so many home-based work, there are so many work which is piece rate work, so many different kinds of work where women go to different people's places. There is no formal factory shed where women are working, but are delivering at different kinds of, you know, even inside the homes. So I do not think this argument is true that, you know, it will intrude into the home space, and also that these workers will increase the number of cases. So be it. Because if so many women, and also I can tell you that, you know, trafficking in women and children is a huge issue, where women have been trafficked, brought into the bigger cities from the interior areas of the country, and given to work in different people's houses without any social protection, without any labor laws, without any kind of working conditions protection. What happens there is that they are sexually harassed, and there are very famous cases that not only harassed, they are raped, they are, you know, molested, and they are not able to complain to anybody. Now in that situation, if you this law will not give coverage to these women, I think then there is, what is the point having law which gives only a section of women coverage?
I get it. Is there a possibility that it could go the way 498 has gone?
It is, and there is
there
the
a threat?
risk. See, there's a risk of abuse. So we have to have sufficient safeguards in place. And this, I'm saying, when most women will not come forth with complaints, we also have cases where there is extreme abuse. I've seen several cases of that nature. Now, within the workplace, within the home, that risk of abuse by a domestic worker for reasons of some kind of extortion is possible. So we just have to make sure that our complaint committees are so good that there won't be a chance of risk abuse.
Why not make gender neutral?
No,
If we make it gender
okay,
neutral, does it serve the
think I
purpose?
don't-
I
don't
haven't,
agree with
I have
that,
an
because
answer to this
gender
gender
neutrality
neutral.
is a gender specific crime. It's a gender, by and large it is, and I think Justice Verma, who delivered the case, certainly supported a gender neutral law. By and large, a democracy should have laws which are gender neutral, but in this case, it's a power relations. It's definitely a kind of, you know, aggression on, or all kinds of exploitation of women, because they're under some kind of a relationship where they're subordinated by the boss or somebody who does that. So I think the crime is gender specific, so law cannot be gender neutral. It has to be a gender
Your input,
specific
ma'am.
law.
You know, I basically think, I've seen the statistics, for example, of domestic violence. And although the law was gender specific earlier, both in the US and in the UK, they've amended domestic violence to make it gender neutral. Now, the reason is that they've apparently, the statistics say that some 20% cases are domestic violence by the woman against the man. But take a case
let's
like
reach that
India.
stage.
No,
Let's reach that
that's
just a
exactly
second.
what I'm saying. Let's reach that stage.
Yes,
I
we
think
come
in
to
India,
that,
we have to
yeah.
wait another 10 years or 20 years
Yes.
before we reach that stage.
Right. On
I'm
that
not
note,
against
So
it,
at the
but
moment, we need to have
Yeah.
specific laws for women to give them protection, so they feel protected at workplace.
It's time for us to head into a break. When we come back, we will show you what advocate and expert Vrinda Grover has to say. Welcome back. My colleague Reshma Roy spoke to advocate Vrinda Grover and tried to get in her perspective.
What is the bill all about?
It also defines sexual harassment, much in line with how Vishakha had set out the judgment, because what is sexual harassment has to be understood. It's not simply about a touch or something direct. There are also a lot of nuance and indirect ways in which a hostile work environment is created, or women are asked for certain kinds of sexual favors, otherwise they are victimized at the work.
Does the bill also include students as well as the educational institutions?
Well, the way the bill was envisaged is that yes, this will, and that's what Vishakha also said, an educational institution is both a workplace for the faculty, for other employees, and not for the students, but however the sexual harassment is very often experienced and suffered by students too. Therefore, what is said is that educational institutions will also come within the purview of the workplace.
You had made a point that if a complainant has to bear the penalties on basis of a false or malicious complaint, then the whole purpose of the bill remains unsolved.
These are going to be difficult cases to establish. To deter, to put in this kind of provision, according to me, is to do two things. One, to ensure that women do not file complaints, and the woman who does file a complaint and is not able to prove it for whatever reason, and there could be a host of reasons. We've also had cases where women's families have been threatened and women have been forced to withdraw. The last time we were doing a case, that woman has actually left the country now in order to start her life again.
The bill talks about both the organized and unorganized sector, but it leaves out the domestic helps who form a large part of the unorganized sectors.
In fact, the largest chunk of unorganized workforce women in urban areas are in domestic homes. They are today the most unprotected and the most vulnerable of the workforce. Excluding them, I think we've made the government is making a very, very serious omission, and there is no rationale actually behind that omission.
Unlike sexual harassment legislations in many other countries, this bill is not gender neutral.
We as a society are ready for a gender neutral sexual harassment at the workplace. It's not as though men are being sexually harassed. The structures of power and discrimination are loaded against women. Men are not scared of walking on the streets of Delhi at night.
The parliamentary panel feels that it should be gender neutral. Former Chief Justice J.S. Verma favors it, but Vrinda Grover doesn't agree. Ma'am, the first question to you is, especially on the complaints committee and the nature and the formation, the way it is formed, the pendency of the complaints that are there, all these issues, how do we actually try, and even till the legislation doesn't come in, we still have the complaints committee functioning. But where is the matter stuck? Why isn't it going forward? Why aren't we actually being able to tackle the situation?
I think two things. One, that it's not clear that what is the power of this committee. Like, we sit on the committees only when we are invited by the institution and when they receive a complaint. Now, they don't receive a complaint is a normal statement coming from every single institution we are member. Oh, there is no complaint. And if at all there is a complaint, it is of the class 3 or class 4 employees. So there is no complaint at the senior level whatsoever. That means there is some kind of a, social barrier within the institutions where women are not able to come and complain. And secondly, when there is a complaint, what kind of a really outcome of that complaint really women receives in terms of justice. What happens is that she is normally, as she thinks that A, she is not socially acceptable in the institution. They want to push her out somehow or other, and also they don't want to give the way women are, they don't want to trust the women's complaint. She has no witnesses there. So I think the empowering the committee is very important, and also ensuring that the committee is everywhere. At the moment, in spite of deemed law, in spite of Supreme Court judgment, we don't have these committees, and they are not empowered enough. An enabling environment in the institution should also be created by gender sensitization.
You had a point to make, ma'am.
Yes, I was saying, in fact, that I've come across several complaints pending before National Commission. There are MNCs which do not have these complaint committees. What will they do with the 50,000 fine? They'll consider it as petty cash. It's petty change for them. You have to have a criminal machinery in case they do not put the committees in place. The committees cannot be ad hoc committees. The committees cannot be manned by people who are junior to the person who's the accused. These are the accused form, recently, where the head of an institution was the person complained against, he formed the committee out of his secretary, his one teacher, one other person. Obviously, such a committee is going to come with not guilty. The verdict has to be not guilty. You have to have a proper committee in place. Vishaka said it should be a committee where the majority should be women, one should be an NGO or and people have to be sensitized to this. Even women, that they can make a complaint, men, that they do not do any such action. And at the moment, if a woman does make a complaint, there is this stupid sniggering, I may almost say, by a whole male group saying, look at this complaint that she's made. And the woman feels actually ostracized because in any case she's in a minority.
Does the bill include all this, does the bill ensure that these things are taken into account as far as the complaints committee is concerned?
Well, the moment you start saying gender neutral, you are really undermining, and you are already making a kind of biased statement against women, saying that, look, I mean, women will use it against men. I mean, this is not true. How many women can afford to go against their institution, their bosses, their workplace, and can survive? Unless it is really, they are in very difficult conditions, they will not complain, let me tell you. And if one or two, I'm not saying that maybe some women goes and uses it politically or otherwise, then there is this complaints committee for what? They will go through everything and they will decide if it is really a false complaint or it is a real complaint.
Ma'am, that's it. Thank you, ma'am, for joining us on this discussion. It is time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.